This is your government video for Selective Incorporation. If you remember, the Bill of Rights was added to the Constitution during the ratification process because the anti-federalists were really afraid that the federal government was going to be too large and was going to start taking away the rights of free citizens. And so they made a deal with the Federalists in order to make a list of rights that the federal government couldn't take away. So the original Bill of Rights only protected you from federal government infringement. The federal government couldn't infringe on your right to freedom of speech or to bear arms. But over time, we realized that it wasn't just the federal government taking away people's rights. The state governments did that sometimes too. So the Supreme Court decided over time to incorporate the rights in the Bill of Rights and apply them to the states as well as the federal government. Now, they chose to do this selectively, or one clause at a time. They did not totally incorporate all of the Bill of Rights in one giant case decision. So when a case comes before the Supreme Court, they make a decision on that, and then in the writing of the opinion of that case, they make it either apply to the federal, the state, or both. Now, this obviously leads to activist Supreme Court decisions because the Supreme Court is interpreting parts of the Constitution in a brand new way. This, of course, can be unpopular to some people. You can apply what was originally seen as a federal government issue to state governments, and a lot of state and local governments don't like that. It has federalism issues. Remember, there is also no immediate check and balance on a Supreme Court decision. So if you don't like the Supreme Court, the opinion that they've done, you can only change the makeup of the courts in the future and have some future Supreme Court decision change that. But there's no way to immediately change a Supreme Court decision. Now, in the Bill of Rights, the original Bill of Rights, remember, applied to the federal government, but starting with the Civil Rights Amendments, 13th, 14th, and 15th, we start to see the writing of those amendments include the language that states are not allowed to infringe on your rights. So the 14th Amendment has some really important clauses. One of them is called the Equal Protection Clause, and it says that no state shall deny any person within its jurisdiction equal protection of the laws. Now, the 14th Amendment is passed right after the Civil War. We, of course, emancipated slaves. All of those former slaves become citizens of the United States. And now we've got to put some constitutional protections in there so that state and local governments protect and treat all of those new citizens equally. That is the intent of the Equal Protection Clause, but it's specifically saying here that the state government cannot deny equal protection. The state government has to protect all of its citizens equally. Another really important clause in the 14th Amendment is the Due Process Clause for the states. There is a Due Process Clause in the original amendments, which applied to the federal government. Remember, due process is the right that you cannot have your rights removed without some type of legitimate process. In our country, that is a trial. And if you're proven guilty in a trial, then of course the government can take your rights away or put you in jail or charge you a fine or something like that. But until the 14th Amendment, there was no due process clause for the states. So they added that in, and citizens now have a right to be protected from state government. The state government cannot take away your rights and liberties without due process. Now, the 14th Amendment is used by the Supreme Court to apply the Bill of Rights through the states, and this is how they selectively incorporate various clauses of the Constitution and enforce them on state governments. This, of course, complicates federalism, which is the balance of power between federal, state, and local laws. Is there appropriate balance of power? If the federal government is using the Supreme Court and using the Constitution to enforce laws on states, is that a violation of the state government's rights? And of course, we have, court systems in both the federal government and in the state government. Each state also has its own Supreme Court, which of course can appeal up to the federal courts. So federalism becomes very important when in front of the Supreme Court. United States versus Lopez is a great example. This is a case about federalism. The federal Congress had passed a law saying that all school zones had to be gun-free. So Gun-Free School Zones Act was passed. It was passed by the federal Congress and imposed all across the country. Well, typically, education in school zones were enforced by state governments and local school districts. And a lot of those local jurisdictions didn't think it was Congress's job to impose laws on local areas. And so they sued. And in United States versus Lopez, it forced the Congress to have to decide if the federal government was going to be able to use its laws, in this case, the Interstate Commerce Clause, to be able to impose districts in local areas. In this one, in United States versus Lopez, the Supreme Court said that the state had sovereignty and local control over school districts. They overturned this federal act. Of course, today, most school districts and states do have gun-free school zones in all of their local districts. But this upheld the right of federalism, that the federal government cannot control local areas. We're going to take a break for active learning number 2. Please put active learning number 2 in your answers to these questions and explanations on your active learning paper.